Charles Chevelle.
Explanation for the questions that were originally posed.
Could I just ask the technicians to make sure that Mr. Chevelle's microphone is live, please? Charles.
Thank you, Mr. Chairman. Just picking up on a couple of the comments that the Minister made in the chair, he assured the House that there was no minister seeking to abuse the powers that were being conferred by the legislation. And I think it's important to stress that the major concern about potential abuse isn't necessarily around the executive. It's around, for example, the powers that might be used or otherwise not used by councils and others under the legislation because of the exemptions being granted. And that's the scrutiny, I think, that members are going to be keen to see the Regulations Review Committee exercise if this bill passes in its present form. The other point that the Minister made was about the need for property transactions to be able to resume and for the parties to those transactions to have confidence. And of course one of the major issues that's been reported today is that there's real difficulty for parties to commercial contracts gaining insurance cover because of the attitude of the reinsurers as settlements come up or as contracts come up for renewal. And one of the things I think it would be helpful for the House to hear is whether or not the Minister thought about trying to deal with that situation at all in this legislation, and if not, whether there is a plan at all to try to address that quite major concern for people who are affected by this terrible disaster. Sir, in terms of the detailed questions on the legislation that I'd be very grateful for the Minister's comments on, the first one relates to clause 6.3, which is a provision that would enact that the recommendation of the relevant minister in recommending to the Governor-General that an order in council be made not be challenged, reviewed, quashed or called into question in any court. Why was it thought necessary to try to enact a clause of that nature at that stage of the process where there's only a recommendatory power and where the courts have long expressed real concern about whether those sorts of provisions in legislation are enforceable? I wonder why it's thought necessary or desirable to have that sort of provision in this legislation, and it would be useful to hear from the Minister about that. With respect to Kennedy Graham, I'm not sure that the SOP that's moved in respect of that clause would improve the situation much, and as I said in the second reading speech on this bill, we would look at the supplementary order papers that have been proposed over the dinner break and express a view on them. The relevant SOP would amend that clause to allow a judge to exercise a discretion effectively about whether fundamental principles of justice will be compromised by not allowing a case to be heard. As I say, I'm not sure that would remedy the situation. It would be good to hear the Minister's explanation of why 6.3 is there. I'm not sure it's capable of useful amendment. It probably should either stay or go. In terms of the rest of the legislation, my colleague Clayton Cosgrove asked some questions about the appearance of certain provisions in the list that appears at clause 6.4. One of the questions I had was around the apparently random nature of the list. The Social Security Act 1964 is mentioned at paragraph S, but no other legislation empowering the payment of any sort of benefits is mentioned. There's no mention, for example, of the student loans legislation or the liable parent contribution legislation. Is it just thought that social security legislation in and of itself is sufficient to be mentioned there, or are there other provisions of that nature that should be dealt with? The rest of what I wanted to say really relates to the supplementary order papers that we saw for the first time just before dinner. Mr Chairman.
I call Charles Chevelle.
Thank you. The Labor Party wouldn't be minded to support the provisions that would bring the bill back to application only till the 15th of March 2011. The government's already confined the application of the legislation to 1 April 2012. We think that's a useful way to confine the legislation. We don't think coming back to the House in 6 months would be a good use of the House's time. In respect of the supplementary order paper to require a certain number of members of the Commission to be appointed by the Christchurch City Council, we understand that that is already the subject of an undertaking from the Minister John Carter, that there will actually be a number of members of the Commission directly representative of the relevant local councils. So if the Minister can clarify whether that is in fact an undertaking on behalf of the Government, it would be useful. The supplementary order paper that requires orders in Council to be publicly available and presented to the House of Representatives is one that, as I understand it, simply reenacts the existing law, but if the Minister has a different view on that, it would be useful to hear whether or not that is the case. The provision requiring orders in Council to be publicly available and presented to the House of Representatives within 24 hours of being made. A summary of what the Minister's understanding of the current law relating to orders in Council and their publication would be useful so we can determine a position on that. And finally, the provisions, the supplementary order papers that would apply the Local Government Official Information and Meeting Act to the Recovery Commission. That seems to be a sensible way to proceed. The Minister hasn't provided for the Commission to be subject to the provisions of the Local Government Official Information and Meeting Act, and it would be useful to hear why the Minister doesn't think Lagoima should apply to the proceedings of the Commission, because certainly it would be the Opposition's view that it should.
Call Chris Tremaine.